For my Choose Your Own Adventure for the second assignment, I chose to analyze and compare legal cases. The cases that I have chosen are number 1, the Ontario College of Teachers versus Quintino Bordenali, which took place in July 14th of 2010, and the second case was the Board of Educators for Toronto versus Higgs et al., which took place in December of 1959. Now, there is a large duration of time between these two cases, but both are extremely relevant, poignant, and critical decisions were reached in regards to the teaching profession, especially that of Ontario's teaching profession. Now, in the case of the Board of Educators for Toronto versus Higgs et al., although this particular court case took place almost 60 years ago, this case provided a platform and a means upon which teachers could be judged and disciplined. The decision can be deemed as a landmark decision, dictating how, when, and by whom those in the teaching profession could be judged legally, professionally, and personally. During recess, the plaintiff was injured by another pupil, who was known to be violent and engage in rough play. The student lifted him off of his feet and carried him over to the ice, where he dropped him directly onto his back and hips. None of the 4 teachers who were supervising actually saw the incident take place. The boy refused help, and another teacher ordered him into line, although he was limping and complaining. He was subsequently sent to see the school nurse and sent home in a taxi. Remember, after all, it was 1959. The boy saw a medical assistant when he went home, who advised him that his hip bone had actually been displaced, which was then aggravated when the boy was required to walk to class. Legal action was taken in which negligence was alleged by the plaintiff against the school board and the teacher himself. They alleged that there was a failure to provide adequate supervision, permitting rough play, which they ought to have known would cause injury, and a failure to intervene when seeing rough play. A decision was reached. The jury found negligence on behalf of all teachers involved. The adult respondent received $510.95 in compensation, and the infant respondent received $10,000 in compensation. Now, negligence is defined as a failure to use reasonable care resulting in damage or injury to another, whether it was intentional or unintentional. These are operative words. The reason as to why I chose this particular court case and the significance and relevance to the courts itself lies mostly in the decision reached itself. This is to say that this particular court case provided a basis upon which teachers in Ontario would be judged from this point onwards. In several of our case studies, the discussion question that was posed was whether or not the teacher was negligent in their behavior. In particular cases that we discussed at length, weeks 2, 4, and 6, the discussion question asked if the teachers or administration were in fact negligent, resulting in harm to the student. This case provided a landmark ruling that we can now look back on and use as a reference for any future court cases in regards to negligence on behalf of the school board and teachers. Although these teachers and the teachers involved in our case study discussions did not intend for harm to be brought upon the student, it does not change the fact that they were in fact found to be legally and ethically responsible for the injuries. No longer was it sufficient for a teacher to say that they were unaware of the possible harm. The legal implications are as follows. There was a failure to adequately care for, provide for, supervise, or protect the child, which is from the Child and Family Services Act. Failure to protect where necessary children who are under the age of 16 years or in the society's care or under its supervision, and to supervise children assigned to its supervision under this Act, the Child and Family Services Act. Failing to supervise adequately a person who is under the professional supervision of the member, directly from the Ontario College of Teachers Act, and to operate the school ground as a park or playground and rink during the school year, or on vacation, or both, and provide and maintain such equipment as it considers advisable and provide such supervision as it considers proper, provided the proper conduct of the school age is not interfered with. And that is directly from the Education Act. In the case of Quintino Bordenali versus the Ontario College of Teachers, It was alleged that Mr. Bordenali had used inappropriate language in his marking of assignments, such as "you suck," "you're lousy," "fatso," "shut up," "you're a drag." Used profanities in the presence of his students, "shit," "bullshit," "son of a bitch," mind my French, told students to "shut up," read poetry that included inappropriate content, "I can't wait until I make love to you," deliberately laughed and ridiculed after a student had presented, and stashed an open bottle of alcohol in his classroom closet, which a student found. This behavior persisted for approximately 3 years before any punishment or the teacher was reprimanded in any fashion. A decision was reached. In May of 2007, the teacher received a 15-day suspension, which was subsequently reduced to 5 days after filing a grievance with the Ontario College of Teachers. Mr. Bordenali pled no contest in that he failed to maintain the standards of the profession, abused a student or students physically, sexually, verbally, psychologically, or emotionally, engaged in conduct unbecoming to a member, failed to comply with the Education Act, and committed acts that would be reasonably viewed as disgraceful, dishonorable, or unprofessional with Ontario regulation. The penalty? Mr. Bordenali was ordered to enroll in and complete, at his own expense, within 3 months of the ruling, a course of instruction in workplace behaviors / professional boundaries and student sensitivities, and to provide a certificate of completion to the registrar within a month, 30 days of completing the course. And that's it. As soon as he finished that, he could be reinstated. Now, the reason as to why I chose this particular case is due to the fact that it is much more recent than the first court case that I chose, and thus more indicative of the penalty that teachers in Ontario face in modern days. In addition to this, it did remind me of the case study discussion which took place in week 1, Billy and Mr. Cole, in which the teacher was verbally abusing a student and using profanities in the classroom towards a student. Although it may not be politically correct in this climate to say, considering that I am currently in the process of becoming a teacher, but it also shows just how protected and insulated teachers are today. Unfortunately, the teachers' union is so strong that it is near impossible to terminate their contracts, as shown by the decision that was reached in this particular case. Now, there are statutes and acts that should protect these students, such as the Child Family Services Act, the OCT Act, and the Education Act, the Ontario Education Act. However, students still are not being protected. If Mr. Bordenali would be reinstated within a month of this decision. In 1959, the strength of the teachers' union had not yet fully been established. However, in 2010, more than 50 years later, the union was so strong that these inexplicable behaviors simply warranted a 5-day suspension and a completion of an instructional course. To say it lightly, this punishment can be defined as a proverbial slap on the wrist. Seeing as how teachers are viewed as supervisors, as instructors of care, and as supervisory models, it is absolutely frightening how and why this teacher was not terminated. Unfortunately, cases like these are not in the minority today, and the safety and job security that can be viewed as synonymous with the teaching profession in Ontario is being used as leverage and as a crutch for shoddy behavior, shoddy teaching, and absolutely vile conduct that is unbecoming to an OCT member. And these are my references.